It's very common for contracts to include conditions on which the contract's performance is predicated. So, what happens when a contracting party fails to make a good faith effort to satisfy those conditions? The case of Billman versus Hensel addresses this question in the context of a real estate transaction. The Hensels entered into a contract to sell their house to the Billmans for $54,000. The contract required the Billmans to pay the Hensels $1,000 as earnest money. Additionally, the contract included a subject to financing clause stating that the contract was conditioned on the Billmans' ability to secure at least a $35,000 conventional mortgage on the property within 30 days. The Billmans gave the Hensels a check for the earnest money, which the Hensels deposited into their bank account. The day after the parties signed the sales contract, Mr. Billman met with a bank representative to discuss a mortgage. The representative told Billman that he couldn't obtain a mortgage for $35,000 unless he could obtain the $6,500 difference between the purchase price and the mortgage. 3 days later, Billman told the Hensels that he was close to securing financing and asked to show his parents the house. After Billman's parents saw the house, Billman told the Hensels that because Billman's parents wouldn't lend him the $5,000 he needed to complete the financing, he was backing out of the purchase. The Hensels responded by offering to reduce the purchase price by $5,000. Billman rejected the offer, saying that he was still short $1,500. The next day, Mrs. Billman stopped payment on the earnest money check. Accordingly, the Hensels sued the Billmans in Indiana State Court, seeking payment of the earnest money. The trial court ruled that the Billmans weren't excused from performance of the contract and awarded the Hensels $1,000. The Billmans appealed.